Well, welcome everyone. I want to be the first to welcome you to our new workers' compensation subrogation webinar series. My name is Ryan Woody, and with me are attorneys Catherine Dowie in Boston and Steve Smith here in our Wisconsin office. I think our goal in this webinar series is to kind of just be able to arm you with the latest information about what's happening right now on the ground regarding workers' compensation subrogation. So we're going to begin by highlighting some recent decisions, pending cases, and any statutory changes that come along, so that you're really at the forefront of the industry and you're armed with the best tools. So one thing I want to let everyone know, obviously thanks for attending, is that we work on our topics about a month in advance. So at the end of today's presentation, we will introduce a new topic for March and let you know what that is. But if you've got any questions or ideas for a future webinar or topic you'd like to see us cover, just let us know. You can email me or anyone here. My email address is rwoody@mwl-law.com. Just go to our website. You can connect with any of us on there. So without further ado, let's just jump right into today's topics. We're going to start out in Oklahoma, where there's a big question of really whether work comp carriers can subrogate at all when paying death benefits. Under Oklahoma's constitution, basically, the right of heirs to recover for injuries resulting in death cannot be abrogated or limited. So plaintiffs' attorneys have latched on to this abrogated or limited language to argue that a carrier's lien is effectively a limitation on their right to recover. So, I mean, admittedly, it's a clever argument, and several trial courts in Oklahoma have agreed with them. There's been numerous cases that have gone up on appeal, and now we've got one case or a series of cases that are pending before the Oklahoma Supreme Court. So, I mean, it's a big issue. I mean, the implications on the industry are enormous. So today, I'm bringing in Steve and Catherine, two of the attorneys who authored NASP's amicus brief in the case, and to kind of weigh in on the pending case and arguments presented. And for those of you out there who aren't familiar, NASP stands for the National Association of Subrogation Professionals. If you're not a member, I encourage you to consider becoming one if you're able to. Without further ado, Steve, why don't you start and unpack this issue? Maybe explain why it's just popping up now and not before.
Yeah, thank you, Ryan. And as Ryan pointed out, and as you see on your screen right there, this argument originates from the Oklahoma Constitution itself, specifically that language on end of line 2, beginning of line 3 on the slide, shall never be abrogated or limited. Now, what the plaintiff's bar is doing is essentially, I mean, they're taking that text quite literally and saying, well, if there's a recovery in a wrongful death situation, the surviving spouse or the decedent's family, that if there was a work comp reimbursement scenario, that would be, in essence, an abrogation or limitation on the wrongful death recovery. And so that's the nuts and bolts of the plaintiff's argument right there. Can we go to the next slide, please? And why this first started coming up is prior to 2014, the legislator didn't have a very strong subrogation statute on point, and work comp carriers were not entitled to subrogate for these death benefits. You can see it right there in the text. I'm not going to read it out verbatim, but the pertinent language is shall not have the right of subrogation to recovery money paid by the employer or insurance carrier for death claims. So that's why this started changing up. There's a change in the law. So then fast forward to after 2014, what happens now is the employee has a right, or excuse me, the employer's decedents have a right to both make a comp claim, as you always could, and bring this third-party action. And so the pertinent difference is the old statute was 8543, section 43. This one is 85A, which was part of the 2014 overhaul. And in 2014, I didn't put the whole statute there itself because it's quite lengthy, but it does what a lot of work comp statutes do. It provides the employer with a right to intervene and claim a right of reimbursement subject to a statutory distribution scheme. In Oklahoma, it's the employee is going to retain 1/3 of the recovery, the employee's the decedent's family or beneficiaries of the wrongful death claim. They're going to retain 1/3 of the recovery, but there is this obligation of reimbursement. And so what we have here is a statute, again, revised in 2014 against a constitutional provision that on its face, it looks somewhat strong, shall not be limited or abrogated. It's a pretty good battle.
Let me jump in with a quick question for you. After the legislature made this change, going from a shall not to allowing work comp recoveries for death benefits, do you know about how long did it take the plaintiffs bar to make this argument? Did they make it right away, or basically did we just start seeing it more recently?
Well, we've been seeing it more recently. They did start making it right away, but it's definitely gained a lot of traction as the issues went up to appeal. They definitely have some storied history on the appellate process, on getting the record correct, and some procedural hiccups on certifying the constitutional question. But they started making it somewhat recently after the 2014 amendments in 2016-17. But it's gaining a lot more traction now because it's finally coming to a head in the appellate courts. And there are a few different cases where this exact issue is pending.
Oh, that's right. You reminded me that in Oklahoma, right? They had to, if you were going to challenge a constitutional provision, you have to put is it the Attorney General on notice?
Yeah, that's correct. And in the Solis decision, talk about it a little bit later, but that's exactly what happened. In fact, that one's very interesting because the trial court originally sided with the plaintiff's argument, which is kind of interesting because the trial court originally sided with this plaintiff's argument that, hey, the Constitution says you can't subrogate. Exactly what Ryan just pointed out, the appellate court said, hey, you have to put the Attorney General on notice of a constitutional argument. It got remanded back down. And on the second go around, the trial court actually flips and takes the carrier's argument. So kind of a Oklahoma procedural history, affect the substantive outcome of the case. Kind of an interesting point there.
Well, I think, and I'm sure Catherine can bounce in too, but I think it certainly didn't hurt to have basically an amicus brief at the trial court level that kind of helped the judge see things differently.
It's what we like to think, is that the amicus briefs are helpful.
Well, I think this is a shining example of where they were because, like I said, it flipped the outcome essentially when more actors got involved. And some of the points we're going to go through got raised, and I think they're, of course, strong points to be made. Again, the plaintiff's argument, you see it right there, shall never be abrogated. There's a lot of issues with this argument. If you take it on its face, it seems strong, but then when you actually parse the language and parse similar statutes, other states where they have similar constitutional provisions, and what's actually happening here, you start to see that language doesn't mean what it maybe on its face looks to say. I mean, at the onset, I'll just say that a wrongful death claim in Oklahoma, whether there's work comp paid or not, it's going to be tried the same way. The same evidence is going to go before the jury. In fact, the jury's not even going to hear, in a typical case, in every case I can think of, isn't even going to hear about the work comp payments under the collateral source rule, which is pretty typical in a lot of jurisdictions, that they're not even going to hear about it. So the general fallacy with that argument is the wrongful death damages aren't being abrogated or limited. Instead, they're being distributed differently. So,
Right, but so the crux of their argument is, right, that because at the end of the day, you're going to take some money away from these beneficiaries, that is a limitation on their recovery. But what I think the courts that have sided with us have saw is that, look, it is not a limitation on your ability to recover against the at-fault parties. What it is a mechanism for how we allocate that recovery once it's made.
exactly. Anything you're doing in the third party action really isn't going to change until after the fact. And then when there is a settlement or a judgment obtained, now you're talking about how it's allocated. But everything up until that point, it's not going to change the measure of damages or how those damages are presented. So it's not really a limitation or abrogation. But where they get their argument from is from an old, well, the main portion of their argument comes from an old Oklahoma decision, Updike, way back in 1955, again, pre-statutory amendments. And I put a little bit of the language in here, and you can see I put dicta run amok because that's exactly what it is. Back in 1955, the Oklahoma Supreme Court was not deciding the work comp subrogation rights as they exist today. Again, those were reformed in 2014. Instead, what the Oklahoma Supreme Court is doing there is saying, well, if a subrogation had been provided by a legislator, i.e. on a hypothetical situation, it would have to be declared unconstitutional because of a conflict, as we went before the Oklahoma Constitution. Two issues in here. One, it's dicta in the fact that they're talking about a statute that hypothetically at that time didn't exist. So they weren't actually ruling over the statute as it exists today. And two, it wasn't even outcome determinative to that case. So you kind of have dicta within dicta. But this was, this was a decision that says the Constitution would bar such a subrogation provision. So I get why the plaintiffs bar used it. But it has serious issues with it. Namely, like I said, it's talking about a hypothetical case. And it wasn't even on an issue that was outcome determinative in that matter. So we're citing, but didn't really carry the day or shouldn't really carry the day on what the outcome should be here. In rebuttal of that, the carriers, some of the arguments we already just said, this isn't an abrogation or limitation. It isn't an abrogation or limitation. It's an allocation of the benefit or the damages in a wrongful death action. And in fact, the subrogation statute goes hand in hand with Oklahoma's long-standing public policy against double recovery. Injured worker, they have the right to both do two things. They can make the work comp claim and they can bring the third-party action. But the fact that a workers' compensation claim is made shouldn't change how the wrongful death doesn't change how the wrongful death claim is actually prosecuted. But if there's a recovery, and I think this was in an Arizona decision that has a similar statute, they're saying that the comp benefits paid out, they're essentially an advance on the tort recovery that will be recovered down the road. So, if work comp were never involved, they wouldn't get the benefit of both systems. But because work comp is involved, they get the benefit of both systems. And in fact, they kind of get more than had comp not been involved to begin with, because in Oklahoma's scheme, they're retaining 1/3 of the damages up top. So they're getting both the benefit of work comp damages and some excess in the third-party recovery, just by virtue of both benefits being paid under both systems. But again, this is the subrogation statute is part of longstanding Oklahoma policy that we're not going to allow people to double recovery. It's not in accordance with this grand bargain of, hey, employers are going to offer work comp without regard to fault. And in exchange, if there is fault, they have certain rights, subrogation and reimbursement. And so that's the crux of the carrier's argument. The other.
So guys, let me jump in, Steve, real quick.
Yeah.
Because you mentioned something really interesting. You mentioned what Arizona, an Arizona decision with a similar statute. I'm wondering, guys, can you speak to, are there other states, a lot of other states that have similar schemes, and what have those courts held on this issue?
Well, I can say, well, Arizona was one of them, and essentially they have a constitutional provision that's exactly like Oklahoma. So is New York. New York has one that's virtually identical, and in fact, the Oklahoma Supreme Court has looked to New York law a few times because the Oklahoma Constitution is, for lack of a better term, a copy and paste of some of the New York statutes. So there are other, Utah is another one that has substantially similar language, but there's other case law, or excuse me, other jurisdictions out there with the same constitutional provision and case law supporting the carrier's argument, this issue having already come to a head in those jurisdictions.
So this is great. And these other outside cases are certainly probably helpful, and you presented some good public policy arguments, but are there any places that we can look to, or where can we look to support a textual reading or compare other particular statutes that would maybe show that the legislature doesn't intend this to violate that constitutional provision? Are there other statutes that this argument would also affect?
Yeah. Oh, Catherine's got it up there. Yeah, there's a few of them there, and this is kind of the one I always think about is attorney liens. It's right up top there, but from the plaintiff's bar perspective, my big issue with this whole thing is be careful what you wish for, because if you're going to take the term no limitation or abrogation, what does that do to an attorney fee in a wrongful death case? It's certainly an attorney lien, as you see it there, is certainly afforded by law. But if you take an attorney lien on a wrongful death claim, is that a limitation or abrogation on wrongful death benefits? I would argue it is. Well, it is if you think the Constitution voids out the subrogation provision as plaintiff's bar argues.
Well, if you think that the constitutional provision really prohibits anything that would result in less going into the plaintiff's pocketbook.
Exactly. Yeah.
And so what are I think you've listed a bunch of other provisions here that would potentially be implicated by this argument. And I'm not sure if the plaintiff's bar has much of a response to this, because I think these other provisions kind of show that the argument here is just too clever by half.
Exactly, and as you can see, quite a few statutes would fall on their face if plaintiff's bar's argument were successful. I'm not sure they'd have a problem with some of these because they deal with other liens, but for sure their own attorney liens, I would think they'd have a problem with that. And it'd create another public policy issue of, people won't be able to find attorneys to take cases if they're not allowed to take a fee on it. So it is a parade of evils, because you see a whole system collapsing, both from plaintiff side and externally from the third parties who have an interest in the suit. Their rights kind of come collapsing on the statute as well.
Absolutely, and I think I'll use this point to just kind of make a point here that the amicus help in this case is something that we were able to dig up all of these particular examples and hypotheticals and put them in front of the court to consider. Because, you know, frankly, when you're the lawyer representing the carrier, or you're in this case and they're challenging this constitutionality, you may not be thinking about the broader scope of the implications. You're just trying to focus on, this is my case, this is this one issue in this case related to XYZ carrier. How do we, you know, interpret this statutory provision? And that's why, you know, getting an amicus to come in and kind of give the court a perspective on, well, how would it affect the industry? What other effects would have on the whole statutory scheme? So I think that was really excellent for us to be able to come in and share that. But like you said, there's a bunch of other cases pending now. Can you kind of give us an idea of what's going on and when we can expect a decision?
What's going on is this issue has been consolidated in a few different cases, and is briefed. There were some hiccups, again, more procedural hiccups on compiling the record and sending it up, but it's brief, and right now I think we're awaiting a decision. How long that'll take, I don't know. But to go back to your point on intended consequences, I think there's perhaps a better example, and it's right in the wrongful death statute itself. Because the wrongful death statute, the ability for the decedent, the heirs or decedents to even family to even bring such a claim, part one of it is that burial expenses are going to be reimbursed to the entity paying that, or the government entity itself. So the actual statute affording a right to bring a wrongful death claim, clause one of it would fail, or at least clause one of how the claims would be paid out would fail. So it's kind of funny that other statutes would fail, but the wrongful death statute itself would have issues, because the first thing you do with the proceeds is pay back for burial expenses, and that would have to go out the window as well. So kind of an interesting point there. And so, yeah, that's right now we're waiting for a decision on this. There's been some indication. There was one case, it was Jones v. Hobby Lobby, where the cert was actually not taken up. Perhaps that's indicative of how this is all going to turn out. Maybe it's that they have enough on the issue, I don't know, but there's certainly I think ample case law both in Oklahoma and looking externally to other jurisdictions to support the carrier's argument here. And
let me jump in and Captain, I know that Jones case, I think you filed a brief opposing cert in that case. Do you have any take on what the denial might mean for the other cases?
I mean, so there are two cases where it was petitioned for cert. One was that Jones case where we think the Intermediate Court of Appeals got it exactly right. They determined that the liens were enforceable. And the one that the Supreme Court decided to take quite a bit later was the Alexander case, which is currently pending. It's under review, and we're just awaiting a decision at this point. But that was a case where the Intermediate Court of Appeals went the other way.
Okay, so that might bear, I mean, it's hard to take any signals, but that might be a good signal that the Oklahoma Supreme Court is thinking that this does not violate the Constitution.
Maybe.
Hopefully. All right, Steve, keep going. I'm sorry to interrupt your track.
Oh, no problem. Well, Catherine just went over the Alexander decision. Again, kind of interesting. All these cases have a somewhat interesting posture of how they got there and what decisions were made along the way. Again, we're pending at the Supreme Court level to see how this all turns out. Going forward, the implications are pretty clear. If Oklahoma rules how other states have ruled, New York, Utah, Arizona, then the work comp carriers, they have a right afforded by the legislator, and it's in accordance with this public policy against double recovery. If they rule the other way, you kind of saw it with the parade of evils. Where does this end? How many statutes topple based on the Oklahoma Constitution? And do you have issues with access to the court system if the attorney lien one statute fails as well? So I think the future implications here are pretty large. I like to hope I like to think we know what the outcome will be. Of course, there are no guarantees in this business ever. But either way, however it turns out, the implications are quite large. I think if the Oklahoma Supreme Court rules correctly and how we would like them to rule, it's going to be in accordance with what Oklahoma has done in other places as far as double recovery and what other states have done with, like I talked about before, have virtually the same constitutional provision on the books. If they'd rule against it, I guess there'd be a split in jurisdictions that way between the different states looking at the same constitutional provision. So yet another implication that could have perhaps large consequences.
All right, thanks, Steve. So we've got the cases pending at the Oklahoma Supreme Court. We're anticipating a decision at some point this year, hopefully. The court's had it for a while. I understand that it took it up on a fast track with some of the briefings, so we're not sure whether the court will set any oral argument or will just issue a written opinion. So hopefully this summer we'll have something. Maybe it'll take longer, but we'll continue to keep you posted on this one throughout our webinar series. But let's just move on quickly to California. There's an important topic that we wanted to cover there. Another situation where we were asked to be involved as an amicus. And Catherine's going to tell you a little bit about that. I would just kind of introduce it by saying, California, while it appears straightforward, obviously it's got many different issues from employer liability to whether to intervene or just file a notice of lien. But I think the one thing that we thought was established or not challenged was the employer's right to a future credit. On paper, and the statute says the credit is automatic. The case law has established that as well. But Catherine's going to tell you a little bit about how claimants have been using maybe a litigation tactic to stall the credit indefinitely, essentially kind of holding the ball. So, Catherine, why don't you take us through what is a relatively high-profile case and explain what happened and maybe give us some tips on how to avoid this trap going forward.
Yeah, so unfortunately what we've learned is that what gets decided in some of the cases isn't always precisely how that's going to play out at the trial level, or in this case in the administrative level in front of the W.C.A.B. So let's take a step back to the facts of this case, which is the Kobe Bryant helicopter crash. One of the women who was killed in that accident has been involved in a workers' compensation claim that we've certainly been following. So as I'm sure most people on this webinar know, there was originally a third-party tort claim brought against the helicopter carrier, and that settled for it's a confidential amount, but it's all the filings indicate that it's a pretty significant amount. And as we also know, Ms. Musser had a workers' compensation claim in connection with this accident that her family was bringing in front of the Workers' Compensation Appeal Board. So what we would expect to happen when the third-party case settled obviously happened. There was a lien. That lien was repaid. But the more complicated issue was there are anticipated ongoing workers' compensation payments. And so what should happen in that case where there are those future anticipated payments and a settlement adequate to compensate for those same injuries is that the compensation carrier should be entitled to a credit and to be able to stop paying out those benefits on an ongoing basis. Now, if the carrier makes that decision and it turns out to be an error, there are always going to be mechanisms for the worker, or in this case, the worker's family, to be able to challenge that and get retroactive payments or even potentially penalties if that decision was made in some kind of error and the court decides that there should be additional payments by the carrier. You don't necessarily have those same remedies if you are the compensation carrier and you've now been making payments for the long term in error, and you really should have gotten a credit at some point earlier on. So in this particular case, the W.C.A.B made the decision that the carrier wasn't going to be permitted to apply a credit following the third-party recovery. And there are a few different reasons that this can happen in a variety of cases, but in this case, the argument is pretty interesting. It's specifically that Kobe Bryant should be treated as an employer in this case because he's the one who told the helicopter to take off. And so the issue here is whether or not there should be a credit or as extensive of a credit because of potential employer liability for the injuries that were sustained.
So Catherine, what you're saying is the argument here that is being used to hold up a valid future credit is that by telling the helicopter to take off, Kobe Bryant was negligent as an employer.
That is what the plaintiff would like discovery on, and that is why the W.C.A.B decided that a trial needed to be held on the credit, and that until all this discovery happened, that the credit shouldn't be applied.
So guys, this is why this is an important issue. And I would not be surprised if this is being if this is going to be copied widespread, because if it's that easy for a claimant to hold up a future credit at the W.C.A.B, we're in trouble here. So, Catherine, so what's going on now? And maybe walk us through why this is so hard to get corrected, which seems to be a simple issue.
You'd think it would be a simple issue, especially if you actually take a look at the statute, which says that the appeals board is empowered, and here's the important language, shall allow a credit to the employer in these situations. This isn't something that you'd think the administrative body was going to have a lot of discretion on, that you'd see extensive denials of. But unfortunately, what we are seeing is that this isn't always so straightforwardly applied in these workers' compensation matters. We're seeing plenty of cases where that credit is denied pending trial. Trial can take there are cases that are waiting around or have to go up on appellate issues and come back down where you may be paying out for a decade before you get a trial on your credit, and that can be really damaging to the carrier. And that's because the timing of the credit is just so critical. The employers and carriers can put the lien on the third-party settlement. They can apply for a credit associated with future benefits. But the problem is that if they overpay those benefits in the interim, so after they've resolved the lien from the third party, whatever they're paying as on an ongoing basis, they don't have the ability to recoup that from the injured worker years down the line if it turns out, oh, we should have gotten a credit. And so there are a lot of situations where just making the delay, just ensuring that the credit isn't applied early enough, especially in smaller cases, is going to be what makes the difference between whether or not there's essentially a double recovery by the worker or whether the carrier is going to be permanently out that money. And so putting the credit in place early is really what's most important in these cases, especially if you've got an amount at issue that might be paid out over the course of 1, 2, 3 years before you're getting that trial.
Right, because we all know you're never going to be able to claw back what's been paid, right? There's really no mechanism. And we don't want to get in situations where we have to sue our claimants for money back. So that is why that timing is so essential.
And so we do have some, really persuasive and actually in California binding appellate authority saying that it would be financially foolhardy to require continued payments in the interim. But unfortunately, what we are seeing is that the decisions we're getting out of the W.C.A.B. on these credit applications have not been consistent. And indeed, there are situations where an individual panel is coming to different decisions on whether or not you should be requiring those payments in the interim. But the problem, of course, is that getting any of these cases reviewed is very tricky, because most of the time you can't take any sort of appellate step when you're not dealing with a final decision that resolves all issues. And the denial of a credit pending trial isn't what we would traditionally think of as a final appealable order. And so even if you're making that application for credit early, even if you're getting a decision quickly, even if you're trying to be really diligent about it, if that doesn't go your way at the administrative level, what you have to be thinking about is, do I want to file a petition for review and try to get this in front of an appellate court, essentially on an interlocutory basis? Now, those petitions are hard to win. Those are really exceptional remedies in appellate law. Those aren't something that are granted often. But one of the things that makes these cases a little more appropriate for that type of review is just that ongoing and essentially irrevocable damage that the carrier is potentially going to have if they're forced to make these ongoing payments. And so that was something that in the helicopter crash case that we were just talking about, the carrier did pursue. They didn't get a substantive answer at the intermediate court of appeals level. They basically just got a one-page order from the court saying, we're not going to review this. And and NASP filed an amicus in support of the California Supreme Court taking certiorari in this case to review this matter, given just the level of conflicting authority that we're seeing at the administrative level, to try to get the California Supreme Court to take this case, to issue a decision, and at a minimum provide some clarity in these administrative proceedings. Unfortunately, that petition was recently withdrawn, and so the California Supreme Court won't be reviewing it, at least in this case specifically. But this is something that, you know, we're seeing happen so often at the administrative level that it's something that, you know, we're definitely keeping an eye out for a case that it would make sense to try to bring back up to an appellate court.
Yeah, just to be clear, I mean, I found this out yesterday. I don't even know if it's been filed yet, but yeah, the carrier changed its mind and said, you know, we don't want the court to take this case up. Now maybe it could be because of the high profile nature of the case, you know, involving Kobe Bryant, the concern that maybe procedurally it wasn't situated correctly. Or that they just want to look for a better vehicle to have this issue decided down the road. But yeah, Catherine's right. You know, if you've got a case that's trending this way, or this is an issue, you know, we'd be happy to, you know, maybe counsel you through that or take it up. But this is an issue that's going to have to be resolved. Any other thoughts there, Catherine, on that the California situation?
No, I think we pretty much covered it. It's an interesting situation, and it's so unfortunate that it's so much a flip of the coin how these seem to be coming out at the trial level so often.
Well, thanks, guys. So everyone out there, I want to thank you for attending. We're trying to shoot for, you know, between 30 minutes and 45 minutes. You know, around the lunch hour, so we're not taking up too much of everyone's time. But we really appreciate everyone for attending this month. As a programming note, next month, Thursday, March 21st, we're going to be taking you through maybe a trend that's occurring in Illinois involving carriers essentially assigning their liens, in many cases to try to avoid Kentucky liability. So is this a strategy you should consider? Is this is a strategy that you could consider in non-contending situations. So we'll talk about what the potential costs and implications are of doing so. Again, we'll also be responding if anything new pops up on these cases or others. We'll try to bring them right to your attention each month. So join us next month. Again, Thursday, the 21st, same time. We'll send out a new webinar invitation. And again, contact us if you've got some ideas for future sessions. Again, thanks for joining us. We will be recording this, and it'll be posted on our website, mwl-law.com, in the near future for anyone to be able to rewatch it or share it with their colleagues. Thanks, guys.
Thank you, everyone.
Thank you.